Yes. Yes, yes, yes. Yes. Madam, just give me the claim. What is the identity of belief you're seeking?
Entire proceedings under the Subsidy Act, recorded as a Bankruptcy Act, and IPC Code, page 17. That means of man there is no difference. Yes.
So, Mr. Nedumbara, how is this happening? How is this happening?
That's why I'm asking.
No, there is a clear bar from filing of suit. Mr. Nedumbara, I have passed judgments on this. There is a bar under the IBC and the Surface Act. You cannot restrain proceedings from being going on. But Mr. Nedumbara, you are wasting the court's time by making such a claim. Yes, you are seeking identity of belief in terms of. Madam, just give me the Surface Act and the IBC. Just give me both. There is a bar, the court can't hear you. Because there is a clear bar from filing of a suit. I'm sorry to say, you can't say it is incorrect.
Which is incorrect. And my job is to demonstrate that it is incorrect if it goes to viewers.
Yes.
Hear me after hearing me for 10 minutes, you want to ask me questions.
Yes. So there are clear bars in Surface and IBC. Yes, okay, you say. You say, Mr. Nedumbara, I'll give you 10 minutes, not more than that. I will give you 10 minutes from the clock. Till 12 o'clock, you can say whatever you want, but no further time.
Yeah, I will. Because if it is intelligent, then it doesn't require the legal system is also a principle that all controversies of a civil nature between the parties to be brought before one forum and this decision also erroneous to be final and binding on the parties.
Yes.
Provided the court has the decision, the court has observed the principles of natural justice, the court has acted in conformity with the statutory provisions, or the court has acted not contrary to the well-settled principles of law. That is the concept of proceeding. Now, under the CPC, under the common law, the policy under the CPC is Section 9 plus absolute jurisdiction on the civil court admitted review or absolute jurisdiction of the civil court to embark upon any controversy of the civil nature under the sun and by the parties.
Yes. Yes.
Now, Parliament in its wisdom is empowered and competent, and the Parliament has indeed did create documents in substitution of the civil court, and in so far as the courts of the tribunals or forums which are so created, measure the jurisdiction and substitution of the civil court is capable of doing what the civil court has been barred from doing, then to that extent, the civil court jurisdiction is on. Now, the first attempt in this direction was international. I am not going to that. The second attempt to bar the jurisdiction of our courts is the recovery of debts and bankruptcy act. I am not taking section. Section 17 of the recovery of debts and bankruptcy act. By retaining the jurisdiction of the civil court, I am not even using that. To decide, adjudicate the claims of the borrower as against the banker. Create an exclusive forum for determination of the claims of a banker as against the borrower. So there are two forms. For a claims of the bank as against the borrower is the other thing. The claims of a borrower as against the bank is the form. Then two forms. Then in 1995, the Agreement was enacted in 1995, the City Bar Association filed a case saying that this enactment is unjust. Primary reason for the lawyers purpose. But they said these laws are unjust because it creates two forms. And the Delhi Court accepted the proposition and said, recover it as a bankruptcy of the Constitution. Then, because the article was that the court was taken coming before the Supreme Court. And the Supreme Court recognised the entry in 2000. And
that's Mardia Chemicals.
No. Mardia Chemicals are the survey in 2002. In 2000, the 1995, the High Court said this recorded as a bankruptcy act is unconstitutional because it creates two forums.
Good.
And they make it adjudication of dispute illegal for a forum. The convention was accepted. Then the judgment was challenged before the Supreme Court, and that continued in the judgment of the Supreme Court in 2000. But in the meantime, Parliament stepped in. Parliament stepped in and wrote amendments. The amendments are section 19, section 19, subsection 5 to 11. This subsection 5 to 11 says, a borrower, if they say, he can take a set off. He has to seek compensation damages. He can seek by the written statement, where in addition to that, other objections he can take the claim for damages, and the written statement shall be treated as a counter suit. And both the claim of the borrower and the claim of the banker, both shall be heard and decided in a one single proceedings by the other. And at the same time, he said, if the borrower so wants, he can insist that my claim against the banker shall be decided by this single court. And the bank also has given the option to insist that if the borrower has raised a claim against the bank, and such a claim is placed before the reality, the reality decided that that can be decided by the civil court. So the option is given. If the borrower wants his claim as against the bank to be decided by the reality, then the reality will take up both claims and decide in one proceeding, and that judgment is final and binding. And if not, the both parties want a separate forum to decide, then we will continue.
Right.
And I will now give the permission that they take the motion to that the word section of the just taking.
Just give me that.
So I will never in my life take a convention. This will stand this custom. It is not
recovery of debts you are referring to?
It is unless you know that you don't know.
Yes.
That is it. Nothing the research was enacted to abolish that. After 2 years it was called.
Yes.
Then there's a reason for it blackmail regimes then came out. Yes. So basic jurisprudence come from law.
Correct.
That is both automatic.
Yes.
Many of the legislations are unless we have the legislative last time.
Yes.
One of the greatest of legislative practical of Dr. Ramsey. They were lawyers. Here the legislations are made by bureaucrats. And I know again that for basic jurisprudence, even the judges they call it that is disappointment, frustration. Basic things. We always need to know, they just need to know. Now I take your
Which section are you referring to? 19?
Section 17.
70.
Section 17 of the History of Excel.
Yes, yes.
I will look up these things I need to take time, but I don't take time. I will need like a spiritual process to do.
Yes.
Section 17 on Washington State, page 94.
Right.
Jurisdiction, powers and authority of tribunals. A tribunal shall exercise on and from the appointed the jurisdiction, powers and authority to entertain and decide applications from banks and financial institutions for the recovery of due to such banks and financial institutions. So nothing else. An exclusive tribunal has been created to decide the case of transaction 1960 about the procedure aspect of it. I thought read but the policy contains section 19 and page 97.
Yes.
Application to the tribunal.
Yes.
Where a bank or financial institution has to recover any debt from any person, it may make an application to the tribunal within the local limits of whose jurisdiction. The three concepts, that's process, this concept. The branch or office of the bank or financial institution maintaining an account that the branch is located. Then B, where the defendant allocating a
That's right. Defendant is located. Correct. That's right.
And then C, cause of action. Well, the cause of action is necessary. So they could stay dominant, the dominant status, the choice of the borrowing statement, and the determining factors are whether the respondent side, primary, well, the cause of action is erased, and whether the property is situated. That's only property. That's clear, that's process, that's interest. Now, this was the original section. Then I take your worship to page 101.
Yes.
101. Then, these amendments were introduced. Yes. 101 subsection 6. Subsection 6.
Yes.
That was introduced, the amendment was incorporated in 2000. And while the appeal was pending in the Supreme Court, the Delhi Court Association appeal was pending in the Supreme Court case. Where are the defendants?
Yes, I have it.
That's our where the defendant claims to set off against the applicant's demand. Any ascertained sum of money legally recoverable by him from such applicant. The defendant may, at the first hearing of the application, but not afterwards, unless permitted by the gentleman, present the written statement containing the particulars of the debt to be set off, along with the original documents and other evidence relying on support of the claim of set off, in relation to any ascertained sum of money against the applicant.
Yes.
Then the written statement shall have the same effect as a made in that lawsuit, was to enable the debtor to pass a final order with respect of both the original claim and the set off.
Yes.
Then a defendant in an application made, in addition to his right of bidding a set-up under subsection 6, set-up while they have a conduct raised, it is the claim of the applicant, any right of claim in respect of a cause of action, accruing the defendant, against the applicant, either before or after the filing of the application, but because the defendant has delivered his defense, or before the time the defendant for delivering his defense is prepared, other such counter claim is in the nature of a claim for damages of law. Therefore, that subscription, a counterclaim under subscription H shall have the same effect as a lawsuit, so as to enable the tribunal to pass an order, when an order, on the same application, both on the original claim and on the counter claim. The applicant shall be regarded to provide interest payment in answer to the counter claim in the defendant in the such case as the case may be, etc.
Yes.
Then every application for subscription 3 or a interest statement of the defendant of subscription 5 or a claim of set-off under subscription 6 or a counterclaim under subscription 8 by the defendant or an interest statement by the applicant in reply to the counterclaim under subscription 1 or any other claim whatsoever. Any other claim whatsoever shall be supported by affidavits on responding by the applicant or defendant verifying all the artifacts and pleadings, the statements and pleadings and documents and other documents with documented as to the application of interest statement or reply to the counterfeit of the case. Provided that if there is any evidence or witness to be left by any party, the evidence of that witness shall be filed simultaneously by the party. Then the defendant may, after giving the appellant and the defendant an opportunity to hear, in respect of all claims set up from the claim, but on the right, it is what is finished. If an interest of such claim within 30 days from the date of the conclusion of the hearing was an claim of final order as against it, which may include order of payment of interest to the date on which the payment of amount is on due up to the date of realization or actual payment.
Mr. Nedumbara, this is all before the tribunal. This is not before the court. All these proceedings are before the tribunal. Mr. Nedumbara, you are wasting the court's time, because what is happening here is that these are remedies available before the tribunal, before the DRT. It is not before this court. This is, you have filed a commercial suit, Mr. Nedumbara. You have filed a commercial suit. A commercial suit first has to satisfy 12A. Now, where is the urgent ad interim relief you are seeking? You are trying to court you are arguing as if you are arguing a final hearing. In the case of a commercial suit, one has to first move for ad interim. Yes. Mr. Nedumbara, where is your avowment in your plaint? Let us take it that you are entitled to file the suit. Mr. Nedumbara, let us take it that you are entitled to file the suit. Where have you said that there is urgency in moving the court? Otherwise, you have to go in for mediation. No, let us say the court is with you on jurisdiction. Let us say the court is with you on jurisdiction. Mr. Nedumbara, then we'll keep it for final hearing. We'll keep it for final hearing. Then where is the question of ad interim? Mr. Nedumbara, Mr. Nedumbara, look at your prayer clause A. Mr. Nedumbara, I have. I don't want you to read every provision. These issues are not really to understand. Let me canvas. I will not really very actually here. So that as time is saying, let me continue my direction of the legal principle without. I don't want to hear the legal principle. I want to hear where have you made out a case of urgency in moving the court. I was there was an order of CIRP. Now you come to that, let me complete that problem. Let me complete that where options is in the meters of we have seen various studying here and there, taking days and days, and research device only working. Mr. Nedumbara, I have a. I am. I understand, Mr. Nedumbara. Let us not go into that, please. You address the case. You address the case. Now, whatever complaint, whatever bringing your lawsuit was basis consideration, I want to take full. Yes. No, I understand that, Mr. Nedumbara. Yes. That's right. Mr. Nedumbara, I have seen the provisions of Section 19. Right. No, I see that. I've seen the provision of section 19. Yes. Yes.
That the legal system provides both parties access. And the dispute of a civil nature, the civil court has to decide. The parliament is empowered and obligated to create a regular substitution of the civil court. And the parliament has created a regular substitute for the civil court in respect of the great and financial institutions, that is the Victorian Legislature.
Right, I agree.
And the parliament also, by amending section 19, by incorporating subsection 6 to
That's right. That's right.
also created a forum for the borrower agreed by the breach of contract and affordable negligence,
Yes.
petition and protest act of the authority of paragraph 16 to plead his case, succeed or fail.
Yes.
So therefore, this affairs that this was the scenario in 2000.
Correct.
Then in 2002, the parliament instructed that there has to be an institution mechanism for recovery of debt, which is secure, which is supported by security interest.
Yes.
So, that is how the Security Act came into existence. I'm not touching it. So, it's that. And thereafter, the section 13 to the Security Act. The banks and financial institutions were allowed to act as a tribunal and to issue a notice to borrower where their claim is supported by security interest, demand them, ask them to make a payment with the distilleries or a failure thereof to the shoppers as to why it doesn't.
That's right. I know. I'm aware of that. Yes.
And they were the borrower fees have been required to such a demand, and the banker and the authorized office of the tribunal has given the jurisdiction to decide that the objection and whether to accept or reject it. And therefore, the body that it was physical possession of the property, the resistance of the magistrate, and the balance of the property, alienate the property, and thereby declare the satisfied state. That is the mechanism of the Surface Act. Then the Surface Act and the Ability Act together constitute one forum, one enactment for the enforcement of the rights of the borrower as against the banker and the banker as against the borrower. And there are various sections of the Surface Act, the safety provision of the economic and bankruptcy act will be applicable. That's why I am not applicable.
No,
So because we have it, then why matters to us in 2016, in 2016, MSME actually.
Yes.
Because there is a lot of many of my friends, lawyers, and many people are already for MSMEs. So the MSME actually, now, without I'm not taking worship, the section that will release only this. Parliament is instructed that MSME is a dynamic sector. And the object clause is, I'm not referring, I'm saving time, I'm not referring to the object clause. I'm only just following one expression which the Parliament legislation has used in the object clause. Yes, that is, the government realized that is a very dynamic system. Yes, the sector, the word used is,
Yes.
this dynamic and vibrant sector of the country's economy.
Right.
And Parliament said yes, and they enacted no.
Yes.
For universal media, and it's there are two provisions in the two sides of the universal media. One is to protect MSMEs from recovery proceedings. One is to make the finance available, lifeblood of industrial policies around finance, and to make the finance available to the MSMEs.
Yes.
Yeah. Then also prevent MSMEs from falling sick. And wherever it has fallen sick, to bring them back to life, revive them by stepping the blessing and care.
Yes.
And that responsibility was given to a tribunal. The tribunal without any of the trappings of a tribunal. Neither judge nor court nor nobody. But by functions, it is a tribunal that is a committee called.
Yes.
It is this. I take ask little time. Many people come and read thousands of judgments. That's so much is time. And they are all silently watching helplessly. I do not do that. I tell your lordship to
Mr. Nedumbra, just pausing here for a moment.
Yes.
See, you may be right on MSME and all that. Now,
No, I don't really catch also.
No.
Even I just continue.
No.
I don't really catch. I'm saying that.
Yes.
Let the PTA members have the I'm saying that. Yes. They're saying that. I'm not touching MSME yet. I'm only saying what is the damage. MSME yet creates a regular substitute for the civil code and says that before an account of an MSME I'm using it as because involved by the parliament itself. Sorry, I'm using one thing, 1 second. Yes. Before an account of a micro, small, medium enterprise turns into a non-performing asset.
yes.
Banks of creditors are required to identify incipient stress. And one of the MSME has stepped in and says, well, a moral. And sorry, I'm reading one section. There are two of the MSME actually. Identification by the enterprise. Any micro, small, medium enterprise may, on an level, initiate the proceedings under this framework if the enterprise reasonably obtains favor of its business or inability or likely inability to pay tax, etc. Here, I as an MSME was anticipating the inability to run my business financial efficiently. I can make an application to the bank for a constitutional recovery.
Correct.
But in this community, 94% of the MSMEs are financially illiterate and all notification says. And that is the reason why this notifications were an issue.
That's it.
I don't know how in this company or
Yes.
this. So then this MSME may voluntarily on its own option when it identifies an insignificant stress can apply. The second scenario is where it is mandatory. The notification is 29/2015 mandates that before a account or an MSME gets into a non-performing asset, banks or creditors, not only banks and creditors, NBFCs are required to identify its stress. And then in this RBI issued notification, telling them these are the signs of insignificant stress. Eventually, signs of insignificant stress.
Yes.
And according to the notification to say that.
You're correct.
Yes, but in that there are many things. Ordinary people like family cautious, not able to understand also. But simply, example of that insignificant stress is bouncing of check. But a bouncer checking of a borrower is MSME is bounced. Then it is bank shall take it as a indication of a sign of an insignificant stress. And immediately goes to pay SME.
That's it. I get it. Mr. Nedumbra, these are all your final prayers. We can consider that. No, Mr. Nedumbra.
Justice is moral injustice. Festinatio, justitio, noverca, infortunii.
Mr. Nedumbra, you have not answered the court's query. Mr. Nedumbra, I'm going to shut you up now. You have not answered the court's query. What is the urgency in moving the matter today?
I am under CRP.
So you are seeking a restraint on those proceedings?
They wanted to sell my company. They wanted to liquidate me.
When was this?
Way back in 2020, all this day order, but I think it's quite a in May of 2020. All gallery aspects, no, they answer what is it. No, but
Mr. Nedumbra, this matter has been placed for adequate relief. You are not answering the court. Leave aside jurisdiction. What is the addendum relief you are seeking?
Absolute stay.
Stay of what?
All recovery proceedings. By suppression, that's why possibility of taking. Because if the question has 1,000 point to discuss my case, dismiss it.
Mr. Nedumbra, I am not dismissing your case right now. You have to answer on urgency. Mr. Nedumbra, you have to answer on urgency.
Urgency is the corporate insolvency resolution clause and the IRP has initiated the declaration process and then invited the applications from the buyers and they wanted to sell my company and this is my bread and butter. Sorry, so it has been brought out of my blood and marrow.
Mr. Nedumbara, this is a suit which is filed in 2023.
Yes, you know, sir, I have no idea how many days have been waited here. For CPF people are given brother and saying. Yes.
What is the status of the NCLT proceedings? What is the status of the NCLT proceedings? No, Mr. Nedumbara, I am not letting you complain. What is the status of the NCLT proceedings? Yes. Yes.
Because this suit as it stands, what I look at is that filing May 23, then after 2024, file an interim application saying whatever has happened subsequent to filing of the suit to stay all those orders. Because the abuse of process of law, blood CPC thrown and thrown to the bin.
Anyway, I am not granting any relief right now. Yes.
Your Lordship, you are not granting here.
I have heard you. Commercial suit, interim application. No, Mr. Nedumbara, I have heard you. Interim application lodging number 1436 of 2025 in commercial suit number 70 of 2024. Heard Mr. Matthew Nedumbara, learned counsel appearing for the latest court applicant. He has moved this interim application seeking a stay of the proceedings under section 13 into brackets 2 close brackets, comma 13 into brackets 4 close brackets, and 14 of the SARFAESI Act, as well as proceedings under the IBC and initiated by the IRP stroke Advocate Commissioner for taking forcible possession of the plaintiff's property described at paragraph 3 of the plaint, and to restrain the defend numbers 1 to 6 in particular from causing sale of shares pledged as security against partly disturbed term loan facility. Next, Mr. Nedumbara has relied upon the various acts which includes the Mr. Nedumbara enough, which includes the recovery of debts and recovery of debts and Bankruptcy Act 1993 semicolon, the Securitization and Resolution of Financial Assets and Enforcement of Security Interest Act 2002, as well as the MSME, that's Micro, Small and Medium Enterprise Development Act 2006, as well as the IBC 2016. He has submitted that under these provisions, the commercial suit has jurisdiction to go into the issue of the MSME Act insofar as the plaintiff is concerned to enforce, Madam, enough, enforce the right and obligations remedies which it has created, in addition to those rights, obligations, remedies recognized by common law, and that the jurisdiction of the commercial court is not ousted. Next. Mr. Nedumbara has referred to the fact that the urgency in moving the present interim application for ad interim relief is that the forcible possession of the plaintiff's property has been taken. Next, considering that passed by NCLT, which are being challenged before the NCLT, and the proceedings are instituted in the DRT and which are being heard by that forum, this court considers that in view of the present suit being a commercial suit, it would require pre-institution mandatory mediation under section 12A of the Commercial Courts Act 2015. Next, accordingly, the plaint filed in the present suit is rejected with liberty to the plaintiff to institute rejected by directing the plaintiff to exhaust the pre-institution mediation prior to filing the suit, and upon doing so, the present suit shall be taken on record and shall be considered. Next, the commercial suit number 70 of 2024 is accordingly disposed of. No, Mr. Nedu, I am not going into jurisdiction. I am not going into next matter.
at least before committing mistake.
I'm not. No. Mr. Nedumara, I've heard you. Yes. No, I've heard you. I've heard you. There's no urgency. Yes. No. Madam, just call out the next matter. Yes. 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 Yes.